Hello, this video is titled Regency Villas, Land Lawyers Just Want to Have Fun. But why have I picked that rather playful title? Well, in this video I'll be exploring the important and fascinating case of Regency Villas v Diamond Resorts, a case which reached the Supreme Court in 2018 and, on one view, has the potential to reshape our very understanding of the essential nature of easements. It's a key case and it will be discussed in every one of your land law courses, and the judgments of the lower courts in Regency Villas are certainly worth reading, but especially the Supreme Court judgment. And you can even watch the full court proceedings online, so do search for those, it's well worth a watch. So why have I called this Land Lawyers Just Want to Have Fun? Well, in considering the implications of this important case, some commentators have said that the Supreme Court has recognised that the right to recreation can amount to an easement in any context, or put another way, that we have a right to enjoy ourselves and have fun, and that right can exist as an easement. Now that's quite a statement to make, and really what I want to probe in this video is how far is that true? Is that really what the court decided? What are the limits of the Supreme Court decision in Regency Villas? That's what I'll be examining in this short video. I should say, if you want to learn more about the case of Regency Villas and hear more about my take on it, do check out chapter 10 of my textbook, Land Law with OUP, and why not also look up my article on Regency Villas in the Conveyancer Journal. It's called Opening Pandora's Box, Recreation Pure and Simple, Easements in the Supreme Court. And you'll find that in volume 83, issue 1 of the Conveyancer. Let's take a step back to reflect on what was at stake in the Supreme Court in Regency Villas, and essentially what makes this case important. To do that, we need to remind ourselves of some of the fundamental characteristics of easements. And the traditional starting point is Re Ellenborough Park, where Evershed MR in the Court of Appeal set out the 4 classic characteristics of easements. And they were that there must be a dominant and servient tenement, the purported easement must accommodate the dominant land, there must be separate ownership or occupation of the dominant and servient land, and the purported easement must be capable of forming the subject matter of a grant. Now, beyond these essential characteristics, there are a series of further glosses, as I call them, which explain or build upon the 4 characteristics set out in Re Ellenborough Park. For our purposes in this video, the key gloss is that there was a long-held and traditional view that rights of mere recreation, rights of amusement or leisure activity, could not give rise to easements. These rights could not, said the orthodoxy, exist as easements. Why not? Well, the oft-cited reason was founded on the work of Theobald and Theobald's Law of the Land from 1929, in which it was said that easements, and this is a quote, must be of utility and benefit and not of mere recreation or amusement. Okay, so where does Regency Villas fit in then? Well, in Regency Villas in the Supreme Court, the court held that sporting and recreational rights, including the use of a swimming pool, golf course, a gym, sauna, in a country estate, did amount to an easement. Now, this has led some commentators to suggest that our traditional understanding of easements has been torn up, rewritten, overturned. Is that right? Is that perhaps to overstate the significance of the case? Just how radical a departure from the orthodox position was Regency Villas? And that's what I want to think about in this video. Certainly the decision calls into question Theobald's assertion that I've just set out, that there can be no recreational easements. Plainly, the easement recognised in Regency Villas was a right of recreation, pure and simple. So Regency Villas definitely challenges this orthodox position. it does find that in certain circumstances, recreational rights can amount to easements. Lord Briggs, who delivered the leading judgment in the Supreme Court in Regency, noted that the main controversy, as he described it, was whether the rights of recreation and sporting rights were said to, or could be said to, accommodate the dominant tenement as required under Re Ellenborough Park. Briggs held, in his view, he said it was plain beyond doubt that recreational rights were of service, utility and benefit. He also rejected the argument based on the case of Hill and Tupper that recreational rights could not be easements as they were merely ancillary to the use of the land. For Briggs, it therefore appeared, and certainly when you read the judgment, to be a relatively straightforward result to reach. Not so for Lord Carneth, who offered a really interesting and insightful, and you could say quite persuasive, dissenting opinion. And again, please read that whole judgment, but particularly Carneth's dissent. Or don't forget to read it, certainly. It's well worth a read. You could say Carneth's dissent is a much more black letter, faithful, traditional rendering of property law. Very interesting read, to compare and contrast the majority view as expressed in the leading judgment by Lord Briggs and the dissenting view from Lord Carneth. Time doesn't really allow me in this video to offer a close reading of Carneth's thoughtful dissent, but in short, he rejected the idea that recreational rights, as appeared in this case, could amount to an easement, for two key reasons, really. He said such rights would require active management and maintenance by the country park landowners, and rights cannot exist as easements if they place positive burdens on servient landowners. Secondly, Carneth said, presented an argument based on authority, but also lack of authority, and you'll see what I mean. Carneth noted there had been nothing in the previous 350 years of jurisprudence to support the view that such an extensive set of recreational rights, as in the case, could take effect as easements. So essentially Carneth looked for authority and saw the authorities that existed and said what authority might there be to support the majority's view, and he couldn't find any. The right claimed, said Lord Carneth, was not or should not be an easement. In fact, to recognise it as a property right would be to recognise something like a wholly new property right, akin to a property right to permanent membership of a country club, which he rejected and said our law has never admitted such rights. How then do we synthesise, or how do we marry together, if you like, the apparent ease and simplicity of Lord Briggs's majority view and the strong and robust dissent from Lord Carneth? How are we to make sense of this? Well, certainly, and as I wrote in my Conveyancer article, Regency Villas, the majority view, will be alarming to some who will see it as an erosion of the fundamental tenets of the law of easements, as if the court has ridden roughshod through Re Ellenborough Park and sanctioned a wholly new species of property right, as Carneth described it. Certainly, some commentators have seized on Lord Briggs's judgment to suggest that almost a right to have fun on land can amount to an easement. Surely, however, and certainly my view is that that's far too unnuanced a position. In my view, such a view overplays and oversells the significance of the judgment. Much weight by those who perhaps oversell the significance is placed on Briggs's assertion that, as he says, times have changed, sport is now vital to the lives of all of us, and Briggs highlights the social importance and social value of sport and the increasing social awareness of the health benefits. However, hold your horses. Yes, times have changed. Sport is arguably far more central to our lives than ever before. But to use that to suggest that the Supreme Court has thrown off the shackles of Re Ellenborough Park and somehow ushered in a free-for-all where anything recreational on land can amount to an easement, in my view, would be a significant misreading of the case. And that, again, that's something that I explore in my conveyancer article, so do check it out. For me, there are 5 grounds on which to resist the temptation to overstate the effects of Regency Villas. First of all, it's not that often that land law cases get to the Supreme Court. Yes, we do get cases now and again, and many cases that touch on aspects of property, but land law cases don't get there that often. And so there's an element, I would suggest, of sort of over-exuberance, perhaps over-excitement, that the case must have changed the landscape in some significant way. Well, yes, the case is important. It has shifted the sands to some degree on the law of easements, but most likely not as significantly as some would suggest. Yes, Regency Villas has nuanced and perhaps even shifted the apparent bar on recreational rights amounting to easements. Clearly, after Regency Villas, recreational rights, even quite extensive recreational rights, can amount to an easement. But there's no evidence to suggest that Regency Villas opens the floodgates and that such an approach will be taken in every case. So we need some pause for thought there. Secondly, and to borrow a famous line from Baroness Hale's judgment in the Trusts of the Family Home case, Stack and Dowden, context is everything. Crucially, the context in Regency Villas was, to my mind anyway, unique and somewhat unusual. This was a timeshare context, timeshare properties. It was also a mixed context where the land in question was being used partly residentially, timeshare development, but also partly commercially. There was a wider leisure complex open to the public. And other elements that make the facts perhaps unusual. The majority in the Supreme Court evidently had a lot of sympathy for the timeshare owners who seemed to have been promised facilities, quite extensive facilities, that had been left to run into disrepair, had been unmaintained and undermanaged. Perhaps the court was looking for a surefire way of offering the strongest remedy to those timeshare owners, and property rights and an easement, of course being proprietary, is a powerful way of offering that remedy. Briggs stressed that a close analysis and a close inquiry of the precise factual matrix of each case was needed. So we shouldn't interpret Regency Villas as ushering in an overly flexible regime for recreational rights. There is no blanket rule after Regency Villas on recreational rights. The court makes clear we need to look close and hard at the particular facts in front of us. Thirdly, the nature of the easement that arose. In Regency Villas, the majority, found an express legal easement. It's very unlikely that recreational rights will give rise to implied easements. I mean, I'm not saying it's impossible. I may very much prove wrong. Who knows? But to my mind, it's very unlikely that implied easements will arise in circumstances other than this express situation. And this offers quite a fundamental and quite an important break on any potential floodgates concerns that people might have about the decision and the impact of the decision. Fourthly, the Law Commission has proposed, in various guises, extending the current regime for discharging restrictive covenants that exists under Section 84 of the Law of Property Act 1925, extending that to easements. Now, this would allow potentially burdensome recreational easements to be discharged and allow for a measure of supervision of these possibly wide-ranging recreational easements by tribunals and courts. So that's another potential break, another reason not to overstate the case for Regency Villas. And finally, I suppose I want to return to the title. So do land lawyers, do judges in the Supreme Court just want to have fun and use the law of easements at the same time? Well, Regency Villas did not wipe away hundreds of years of law on easements. Yes, it does nuance and alter the approach to recreational rights. It did, on the facts, identify that a right to use a range of sporting and leisure facilities did and can amount to an easement, and that is important, but only after a close analysis of the facts of the case, and I say somewhat unusual circumstances. And crucially, the majority stressed that a right such as those arising in Regency Villas can only amount to an easement if it also satisfies all the other essential elements of the re-Ellenborough Park test. So yes, of course us land lawyers want to have fun. Of course times have changed and sport is more important to us all today, and more important perhaps than ever before. But you need to read Regency Villas very closely to avoid over-egging the pudding, overstating its clear significance. Do bear this in mind when studying the law of easements, and do avoid that trap of thinking that post-Regency Villas, any right to have fun or play sport on land will amount to an easement.